Most people are legitimately concerned about when they're going to go to jail. So we're going to talk about what the appearances are and what the court appearances are in a felony matter. Felony drunk driving and other felonies. In a felony, the first appearance is called the initial appearance. A person will either be coming down from jail if they've been arrested, or they will be summoned in by a notice from the district attorney's office compelling them to come to court for their first court date. At the initial appearance, bail is set. Bail can either be a signature bond, which is a promise to pay an amount if you fail to show up for all your court appearances, and it is a promise to come to all your court appearances. A monetary amount is set, but no money has to be paid on a signature bond. On a cash bond, an amount is set, and the defendant or someone on his or her behalf needs to pay that amount of bond in order to get the defendant out of jail until the next court date. Failure to appear at that court date or failure to file other conditions of bond could result in a rearrest, possibly another bail jumping charge, of the cash bond that had previously been posted. At the bail, there is also conditions of bail. Conditions on a drunk driving usually include things like no further violations of the law and absolute sobriety. Sometimes, but not always, machines are used to show that a person is sober because they have to blow into it, or they have to go to the police station and prove their sobriety. At the bail hearing, or once somebody has an attorney, the next procedural step is the preliminary hearing. At the bail hearing, if the defendant does not have an attorney, there are further proceedings to procure, so that the person has time to go get an attorney. If the person has an attorney, then they can either request the preliminary hearing within 10 days if they're in jail, within 20 days if they're out of jail, or a defendant and his attorney can decide to waive the right to have that hearing within the 20 days. At the preliminary hearing, the state must show, 1, that a felony was committed, and 2, that the defendant probably committed the felony. In order to do this, they need to produce evidence. It used to be a much more complicated hearing. These days, because hearsay is admissible, frequently one officer alone testifies and puts in all the evidence through hearsay of all the witnesses and other information. At the end of the preliminary hearing, the defendant is either bound over for arraignment, meaning to face the felony charges, or the matter is dismissed or amended. In 95 to 99% of the cases, the defendant is moved on to arraignment. At the arraignment, the defendant either pleads not guilty, or guilty, or remains mute and asks the court to enter a plea on the defendant's behalf. If the defendant remains mute and tells the court that they remain mute, the judge will actually plead not guilty on the defendant's behalf and move the matter on to further proceedings. Then, after the arraignment, and only after the arraignment, can the defense attorney file a motion for discovery. Discovery means that you want the opportunity to get all the police report, evidence statements, videos, and to see the evidence against you, or against the defendant. The state also files a motion to get the information that you plan to use at trial that shows that you're not guilty. So it's an exchange of information. More importantly, motions such as a motion to suppress evidence because of either an illegal stop or an arrest, motions for collateral attack, motions to suppress statements, those sorts of things are flushed out and filed. Then, if there are motions filed and they're meritorious, the judge will schedule a motion hearing. Then, after motions, the matter is scheduled for a trial. Then there is either a trial or a change of plea, because all the time during this time, negotiations can take place. Then there's either a trial or a plea. If it's a plea in a felony case, if it's a drunk driving third and subsequent offense, the defendant must go to jail. So frequently pleas and sentencings are done at the same time to avoid a person on a drunk driving case just waiting in jail to find out what their sentence is going to be. On the other hand, in many other cases, there's a pre-sentence investigation that's done, and in cases other than drunk driving third offenses and subsequent, the defendant can be released on his own recognizance on the same terms and conditions of his bail. Only in drunk driving cases is that not permitted. At the sentencing, the prosecution argues for what they believe the sentence ought to be. The defense attorney argues for what he believes the sentence ought to be. The defendant is given the right of allocution, meaning they get to say what they think should be done and to say what they think the judge, what they want to say to the judge before the case is disposed of. And then the judge sentences the defendant to what he believes is the appropriate amount. The judge is not bound by the parties, that is the defense or the prosecution's stipulations or plea agreements. Until the time of plea and sentencing, if you're out on bond, you're not going to jail for any of the other court appearances. So don't be losing a lot of sleep, failing to eat, relax, it's going to be okay until you get found guilty, plead guilty, and are sentenced. Thank you.